Welcome to the Fair Housing Insiders. We are so thankful that you joined us. And please remember to subscribe here on our YouTube channel or follow and like us on your favorite social media outlet, which you can find links to in our show notes for even more fair housing news and insights.
Hello, everyone, and welcome to the Fair Housing Insiders, another special episode for today's session. Recently, we talked about some new HUD guidance in a special episode. Today, we're focusing on some new HUD regulations, particularly criminal history screening. I'm your host, Jonathan Saar, and today we are joined by Leslie Tucker. So we look forward, Leslie, to you giving our audience, our community, some insights onto this very important topic. It's generating a lot of buzz, a lot of questions from our community. So we're grateful that we could get this inserted into our regular rotation of content and be able to help out our property management community. So let's dive into it, Leslie. These new regulations, when did they come out, and do housing providers need to change their policies right now?
Hi, Jonathan. This is big news. And I hope that everyone out there listening pays close attention to some of the details that we're going to talk about today. So in regards to your question, the new regs, when did they come out? Well, to clarify, these are not final regulations. These are proposed regulations from HUD. They came out on April the 10th. Proposed regulations always come out first to give people sort of an idea, a sneak peek, if you will, as to what the agency is proposing will become law eventually. And then the public has an opportunity to comment, give their opinion on, what is published in these proposed regs. That period closed on June 10th. And then after that, HUD will sort of take everything into account, read the comments, and then, several months later, will publish the final regulations. Do I anticipate the final regs looking a whole lot different than the proposed regs? Probably not. There may be some small changes here and there, but I think, the overall, big changes within these regs will probably stay within when they're finalized. Do housing providers need to change their policies right now? No, I actually wouldn't recommend doing that because, again, at this point, these law changes are proposed. They are not final. So I would hold off until HUD publishes the final regulations to go ahead and make your policy changes. And I will say that, if these regs do apply to you, you will be making changes to your policies at that point.
Okay. Very, very important statements there. Thank you, Leslie, so much for providing that background and what action items need to be taken and what needs to be planned for. So another question for you. Who does this affect? And should all properties be changing their policies to comply with these new rules?
So who do these regulations apply to? That's a really important question. They apply to housing authorities and any HUD-funded properties or properties with HUD-backed mortgages. So 221D3. While that sounds sort of limited, it certainly applies to a lot of different properties out there throughout the country. If you operate housing that does not fall into any of those categories, I would still encourage you to continue to listen to all of this information, simply because I think these regs form a lot of what we can guess is going to be the basis for HUD's thinking going forward in its enforcement of the Fair Housing Act for all properties. So while every little, nitpicky regulation won't necessarily apply to every property, it's still, I think, going to be helpful for you who run conventional housing or just tax credit housing, RD housing, to know that some of these stricter policies may be coming down on you too, because this is now, what HUD considers to be reasonable.
Okay. So you mentioned a little earlier that at a future date that these are going to be enforced as part of the new regulations, maybe some minor changes, but for the most part, that's what we could and should plan for. With that in mind then, so what are some of the biggest changes when it comes to screening policies and procedures that are found in the regulations? What did you notice?
Yeah, so the regulations, the proposed regs, as currently drafted, are very long. So, of course, I'm not going to sit here and read them off to you, but I will talk about some of the really bigger issues that I saw within the proposed regs. And the first one involves the look-back period that you use when screening applicant. We haven't really been given any sort of definite or concrete guidance on this leading up to these regs being issued. I still have clients. I have clients that use, a 7 to 10 year look back period for some types of convictions. I have 3 to 5, 7 years. So sort of across the board is what I'm seeing among my clients now. In these regs, it's going to require all properties that fall into those categories that I just mentioned, all HUD-funded properties or HUD-backed mortgage properties, to limit their look-back periods to no more than 3 years for all crimes, all convictions. And what HUD states is that if you consider convictions that are older than 3 years, it is presumptively unreasonable. The proposed regulations do not, give a list of what convictions HUD thinks you should consider or not consider, what types of offenses. It just basically gives you sort of this look-back period and the limitation on the look-back period. You are still permitted to consider sex offender registries, which I know a lot of people have been concerned about. That doesn't seem to be touched within these regs. And the only sort of, possible exception that is given in these regs is that if a housing provider believes that they should apply a longer look-back period than 3 years, they have to be able to justify that with empirical evidence that they need to look for a longer look-back period in order to keep their residents safe. It can't just be a belief. It can't be, a common sense opinion. It has to be justified with empirical evidence. So that's kind of the only, crack that HUD left in the door for altering that look-back period limitation. So that's the first issue that I saw. The second one involves individualized assessments. Individualized assessments, I'm sure lots of you know what that means. This is basically kind of a meeting that an applicant is permitted to request, where they can come in, meet with, a decision maker and discuss mitigating circumstances, discuss why, yes, I have this criminal background, but I'm still going to be a good tenant, and here are all the reasons why. Just kind of giving some additional information to consider in that decision. Up to now, whether a property provides the opportunity for individualized assessments is kind of discretionary. They can do individualized assessments, but it was not required. It is now, under these regs, a requirement that you permit an individualized assessment for all applicants whose criminal background gets flagged based on your criteria. A housing provider would be required for any applicant that gets flagged for criminal background to send a notice to them, letting them know that this has occurred, giving them a copy of their criminal record, and giving them at least 15 days to request a meeting to come in and have this individualized assessment. You are not permitted under these regs to issue a denial letter before they are, given these 15 days to come in and have a meeting. So, this changes some of your processes potentially, because as of now, I know a lot of companies use, screening companies, and they kind of automatically generate a denial letter if this person fails their criminal background screening. That denial letter cannot be issued under these regs until, that 15-day period comes and goes. If you have a meeting, you have to make a kind of a decision based on whatever information is given to you during that meeting. Those decisions can be, unfortunately, inherently subjective, based on the different information that certain applicants give to you. And I think that's a big concern about these new regs, is that it kind of takes the objectivity out of a lot of the decisions. And I think we're just going to have to, field those concerns as we go, kind of all of us together. And the last kind of big change that I'm going to mention today involves terminating someone's lease, a current resident, for criminal activity that occurs during their tenancy. This is still permitted under these regs, but under the regs, they give a sort of different standard that housing providers have to follow in order to make that decision to terminate. And that is, they have to determine that this person engaged in criminal activity based on a preponderance of the evidence. And, so that doesn't mean that a housing provider can sort of hear that something happened, someone maybe reported that something may have happened. There has to be a preponderance of the evidence that this person engaged in criminal activity, in violation of the lease, in order for you to make that decision. So that is, I think, very different than the decision-making that's currently going on, and, will require some alteration of housing providers' procedures. So those are kind of the three big issues that I see in these regs. It's certainly not the only changes or issues that are brought up, but we can certainly go over that in a later episode once the regs are finalized.
Welcome back. These videos are powered by our friends at Digital. Their team harnesses the power of AI and automation to handle the heavy lifting for you and your leasing team, and they understand the complexities of fair housing compliance. Their platform, Fiona, streamlines the process, ensuring each property's digital footprint is not only effective, but also fully compliant. Check out their website to learn more.
Yeah, that's a lot of meaty material there, Leslie. And it opens up a lot of, I'm sure, questions for our community on what's that going to look like once those get enforced and passed. So maybe a question that our community is asking, we can put this out there for you to give us some comments on. Look back periods, like you mentioned, with your clients had a lot of different, perhaps, criteria, how many years, so on and so forth, particularly for liability purposes. So with it being changed to 3 years, potentially, is that a concern for housing providers now with liability? Like, say, for instance, a resident with a criminal record causes someone harm? Are there, what's your thoughts on that? Are there any protections in those situations?
I think that's a great question. And it's one that I've heard a lot from my clients, this very concern. And I guess the answer is there are no specific protections that I'm aware of that would shield you as a housing provider from liability. Now, these regs in and of themselves, I think, can help in justifying the decisions that you're making from for applicants. It takes the kind of discretion out of the process and kind of gives you more of a very strict guidelines that you have to follow when it comes to accepting applicants. I've heard of at least one state that has tried to pass legislation that specifically does protect housing providers, based on these criminal history decisions. I don't believe that actually passed or has not passed yet, but that could be something that states are going to be looking into more and more as these regs take effect.
Okay. Thank you for that. So, what you mentioned this a couple times in your comments, talking about third-party screening companies, and a lot in our audience they use that service. So, what does that look like now? So, with these new regulations, can a housing provider continue to use third-party screening companies?
The answer to that is yes. You can still use third-party screening companies. HUD doesn't love the use of third-party screening companies because those companies don't take into consideration other factors, these mitigating circumstances that are unique to every individual circumstance. Third-party screening companies look at a set criteria, they apply it equally to every applicant, and it's either an accept or deny. And that's what housing providers love about using third-party screening companies, and that's what HUD doesn't like about them. So are you prohibited from using them? No, you are not. You can still use third-party screening companies, but be aware that you cannot shield yourself from liability based on a third-party screening company's decisions. A housing provider is 100% liable for the actions and decisions made by third-party screening companies that you contract with, or that whatever software program that you use, and ensure that if you are using these companies or these software programs, that you are in charge of the criteria that's being entered, that you're not kind of taking their recommendations for what the company thinks should be the screening criteria, that you are doing, your own due diligence to make sure your criteria is what it should be, and, that company or software program is applying that exact criteria that you have created. So there is a risk of liability, certainly, for using third-party screening companies. But if you are doing it carefully and responsibly, I think, it's still something that you can still maintain within your procedures.
Understood. Yeah. So there's so much to this topic. We're able to cover a lot, though, in this particular episode. So thank you so much, Leslie. And as you mentioned earlier, we will have more episodes, particularly on this topic, as some more details come out and how we can help provide you with more education on what HUD is releasing. So thank you, Leslie, for your insights, providing a meaty summary of some of the higher level points that the industry needs to pay attention to. So we're very grateful that you could share that with us today. And for our audience, thank you for being here. So this is another special episode, kind of a follow-up to the one we had recently, specifically on criminal history screening. So we appreciate you being here. Thank you for joining us. We look forward to seeing you next time. Take care, everyone.
Thank you for joining us, and we can't wait to hear your feedback about today's episode. Do you have a topic that you would like to see discussed in a future episode? Feel free to share that with us. In the show notes, you'll see a link to sign up for our newsletter. This newsletter will keep you up to date with our latest episodes, blogs, and information about our online fair housing courses. Thank you again, and happy training.